Independent contractors and superannuation. Most businesses think contractors handle their own super, but as a solicitor at Williamson Barwick, specializing in employment law, I see businesses make costly mistakes with this assumption all the time. The reality is your obligations as a business owner aren't always clear-cut. In fact, there are specific circumstances where you must pay superannuation for your contractors. In this video, I'll explain when businesses are liable for contractor superannuation, the key legislation that determines your obligations, real cases that show exactly how these rules apply, and what this means for your business. Let's start by looking at when the superannuation guarantee applies to independent contractors. As a starting point, we need to consider the provisions of the Superannuation Guarantee Administration Act 1992. The terms employer and employee have their ordinary common law meaning under the Act. However, Section 12 of the Act expands the ordinary meaning of employee to include categories of persons who are not common law employees. Specifically, Section 12, subsection 3 of the Act says, if a person works under a contract that is wholly or principally for the labor of the person is an employee of the other party to the contract. This definition can capture many independent contractor relationships, but essentially, where a business engages an independent contractor mainly for their labor, the business is liable to make superannuation contributions on behalf of that independent contractor. Let's now consider how the case law interprets Section 12, subsection 3. In 2020, the Federal Circuit and Family Court of Australia, in deciding the case of Dental Corporation Pty Limited and Moffitt, held that 3 elements need to be present for this section to apply. These elements are: there is a contract, whether it be in writing, oral, or implied. The contract is wholly or principally for the labor of the person. In other words, the contract suggests that you are paying the person in question for their personal labor, and the person must work under that contract. Where all 3 elements are met, an individual will be considered an employee under Section 12, subsection 3 of the Act, and the employer will be required to pay the superannuation guarantee. Now, for a contract to be considered wholly or principally for the labor of the person working under that contract will need to be compensated wholly or principally for their personal labor and skills, perform the contractual work personally and not have any right to delegate that work, and generally be paid for hours worked rather than to achieve a specific result. This case of Moffitt was important in highlighting how businesses need to approach contractor agreements, particularly when those agreements have delegation rights. What seemed like a minor contractual detail could now be the difference between owing substantial super payments or not. Now let's look at another case that provides us with a practical understanding of how the courts will apply Section 12, subsection 3 of the Act. This is the case of JMC Pty Limited and the Commissioner of Taxation 2023, and it is another Federal Circuit and Family Court of Australia decision. JMC was a provider of higher education programs. JMC engaged Mr. Harrison, a qualified sound technician, to provide teaching services by delivering lectures and marking student exams for a bachelor's degree course. Mr. Harrison's short-term written contracts included a contractual right for him to subcontract or assign the teaching services he was engaged to provide to another person, as long as JMC agreed in writing for him to do so. JMC considered Mr. Harrison an independent contractor, and on that basis, did not pay any superannuation contributions. The Commissioner of Taxation challenged JMC's position, and in the first instance, the court found that Mr. Harrison was an employee. It is not perhaps surprising then that JMC appealed this decision, and on appeal, the full bench of the federal court found that Mr. Harrison was not an employee within the ordinary meaning of the term or under the extended definition in Section 12, subsection 3, nor was the contract wholly or principally for his labor because of his contractual right to subcontract his services. The full bench's reasoning behind this decision was that it was not relevant that Mr. Harrison's right to delegate required approval from JMC. It was the mere fact that such a right existed that excluded Mr. Harrison from the definition of an employee under Section 12, subsection 3. In other words, it is the rights under a contract that were considered by the full bench rather than the performance of that contract. This is an important decision as it highlights the court's approach to applying Section 12, subsection 3 of the Act, and it confirms that the terms of an employment contract are paramount in comparison with the actual performance of the contract. To ensure your business stays compliant with the extended definition of contractors, consider ensuring that your contractor agreements clearly specify whether work can be delegated or not, and getting professional advice on your existing contractor agreements. These steps could save you significant costs and potential superannuation liability and penalties. I hope this video has provided you with some useful information, but if you do have any questions about the superannuation guarantee for independent contractors, please get in touch with our team. We would be happy to assist you.